Yeah, it's lit. Okay, I'm almost wasted and my drip is on a spaceship. One more sip, yes, I can taste it. Come to my exact location. I'm so tired of my probation. Doing time for real vacation. I just toasted this occasion to give myself standing ovation. What I'm drinking, that brown, that white, up with the bar sirs. That ass is attractive like a magnet. I never dodged her. Why drink my problems away? And that alcohol is my sponsor, and I will indulge it to the point of death. That's only if my heart hurts, cause relationships never last, and being faithful is a thing of the past. Everybody's only after one thing, both sexes can relate to that. Can we place a bed when I hit it from the back? Get your face in my pillow when I palm on your ass. Yeah, I graduated from the bottom of my class, now I'm sitting at the top, you see the bottom of my glass. We can keep talking, I know this won't last. Yeah, yeah.
You're rocking with the best. You're rocking with the best. You're rocking with the best.
The trust in my client's case has been closed for 3 years. REMIC tax law prevents them from transferring any assets into the trust.
Separates me and separates our group from the rest is that we're willing to go down roads that many teachers and groups just will refuse to go down to because it's going to be too confusing to understand, too time consuming. Like, we've had classes on reading a balance sheet. Do you know that is ultra technical? That's bank examiner's job. We study securities law and accounting. You never find a professional that knows both.
Hi, I'm Jim Bullock. Ever wonder why so many pro se lose in court? It's simple, ridiculous, and stupid. They refuse to follow the rule.
This is the only way to stop a foreclosure. The first thing you got to do is create a trust. The second thing you have to do is file that trust at City Hall. And the final stage is understanding what a mortgage is. When you're at the stage of foreclosure, all the bank is arguing is that you breached your fiduciary agreement when you signed the promissory note. When they start the foreclosure process, all they're stating is that you violated the terms of your agreement. A breach of fiduciary duty is when someone has a responsibility to act and fails to do so. So when you got your mortgage, you signed a promissory note. But here's what attorneys won't tell you, is that during this foreclosure process, the bank has to prove that they actually sent you any money. So once you understand this, you can countersue or make a counterclaim that the bank breached their fiduciary duty because they never gave you money in the first place. So how can you pay something or repay a debt when they never gave you anything? So once you understand that, you put your house in a trust, you understand this process, and you really understand it's estate embezzlement, then your house becomes secure, and look at the results. As you can see here, I have at the bottom, right here, that the plaintiff, who's Deutsche Bank, who's been charged with fraud multiple times by the federal government, the plaintiff files the instant complaint to rescind the foreclosure sale and revert ownership of the property to the defendant. And you see the defendants here above are my mother and father. For more information,
most banks are illegally foreclosing on people, and here's why. So when you have a debt, especially a mortgage debt, the promissory note that you sign at closing is evidence that that debt exists, okay? So the only person or entity that can collect on that debt, or the mortgage security. The mortgage is security, making that house collateral, okay? That's what a mortgage is, making your house collateral for that promissory note debt. I hope I didn't confuse you. The only entity that can foreclose on that is the one that has the original wet ink promissory note. Now, I'm in beautiful Salt Lake City, Utah, waiting to meet one of my students to go to his mortgage lender to make them produce the original wet ink promissory note. They don't have it, y'all.
Welcome to this live stream by the New Culture Empire. Today, we dispel courtroom myths about foreclosures and why these claims are popular among social media platforms. For more information, please subscribe. And if you need more information on services, send an email to thomaslegacy603@gmail.com.
You're rocking with the best.
On my wrist like a stage they can't claim. You look like you wanna let go straight. I thought so, okay. I'm back in this symphony, stuck on a bed. I know they love, no, they love, no, they love, no, they love.
You're rocking with the best.
Gotcha, bitch.
Yeah. Ain't been too wonderful again.
Have to be able to bet on yourself and believe in yourself even when the whole world tells you you are an idiot. You have to be able to even risk your relationships in the pursuit of your dreams and being great. Because everybody can't come. Everybody's not going to support you on the way up. Everybody's not going to support you in the building stages. They all support you after the success.
Legacy. I got knowledge, I got money, you know I am a trendsetter. Yo. Welcome to the Supreme Elite Team University, top of the pyramid, what I prefer to be. Too many secrets that we don't tell. Y'all still living in the show and tell. Y'all still giving out the old paper trails, getting caught in the cross like O&L. We call it play, but you call it chess. I call it state, and you call it feds. You need a scholarship, just call it kid. Heard you need a scholarship, just call it kid. You better hope that we do the honors before we sell out and do what we promise. Ay, that's a double entendre. We gon' sell out, do what we promise. And if I don't, it's sell out.
You're rocking with the best. You're rocking with the best. You're rocking with the best.
Welcome to the New Culture Empire. I am yours truly, your teacher's teacher, the trendsetter, the guru's guru. I'm the one your teacher goes to get their information. And I am the corporate finance company's slayer. Now today, we will hold court. Court is now in session.
I will slap the shit out of you, boy. I will slap.
Now, I will say, before we get into case law, before we get into the overwhelming court authority, before we hold court on the REMIC late assignment void versus voidable arguments, I will add that I've started to see an uptick in doubling down on these arguments after I dropped my last video when we went over the case. Actually, it was a live stream with the video. Make sure y'all check that out, because that live stream and the video that was repurposed from it, that was actually appellate court case law. That wasn't district court. It wasn't any of that. It wasn't like the regular superior court. It was appellate court. Now, before we actually begin, let me just give everybody a fair warning. There is this case that's been circling around social media, and I want to warn everybody so when you see it, you will be aware. Many online teachers are recycling the Phyllis Horace versus the LaSalle Bank, which was a state case out of Alabama, I believe, in 2011. That case is from 2011, and it was in Alabama. That case is not a good teaching point or reference because, number one, a ruling in New Jersey has no bearing on New Hampshire. A ruling in California has no bearing on Virginia. Let's go to the federal side. A ruling in the Fourth Circuit does not control what the Sixth Circuit does. Jurisdiction does matter with these arguments. So what I've done for everyone is, and what I do normally, is I don't look for one case where the borrower won if the next 15 cases after that, they all lost. And that's what you got for the Phyllis Horace case versus LaSalle Bank. That case was not appealed. Phyllis Horace won that case. But the reality of that is she was the very first one through the door, and it was right at the time where courts were still mad at the banks because of they caused the recession. No one in Alabama has won that argument since then. And courts in Alabama, appellate courts, and courts all across the United States, whether in state court or federal court, what we're going to go over today, this is what all the courts have consistently come together and ruled. So when I do it, it doesn't matter if the case is centered in California today, because California is one of the big foreclosure states, was one of the big the first securitization argument started coming out of there. It's kind of the landmark venue. But the difference between me citing these California cases today, and you're going to have other state cases, is that not only do I have California, I got multiple cases from multiple states where all the courts are saying the same thing. So that's what you call consistency within the case rulers, so you can get an understanding on how the courts in their procedural history and how they are going to move. Now, before court takes place, we are going to cover some of the myths. And what I want what I want from you is I want everybody to be the jury. I want you all to be the jury. I am going to prosecute the REMIC arguments. I'm going to prosecute the REMIC arguments. So you have the REMIC arguments. Those are the defendants. Those are everybody that you see online that's talking about late assignments, remix, and all those things. You have me, the plaintiff. I am prosecuting these people. Now, you've probably heard that in a mortgage, that if a mortgage was transferred into a REMIC trust after its closing date, the foreclosure is invalid. And yes, that does sound powerful. But here's the real question. Does that argument actually win in court? Today, we're putting that argument on trial. Ladies and gentlemen, welcome to the New Culture Empire.
You're rocking with the best.
Now, let's do a little trial has begun. It is my time to give my take, and that is what I'm about to do. Opening comments from the plaintiff. Your Honor, today is not about whether late assignments voids the borrower's obligation. As you can see, Your Honor, the borrower refused to pay. Now, apologize. Let's have court. Jury, y'all been sworn in. The bailiff is there. You've already had your instructions. And the question on the table is, does a late assignment of a mortgage into a REMIC void the assignment, thus the foreclosing party lacking the standing to sell the home or bring the suit? That is the question that is on trial today. So let's get into it. Now, Your Honor, this shouldn't be a hard decision for the court to make today. What the defendant is attempting to do is to assert beneficial ownership rights in an agreement that they are not a signatory or a party to. The argument of a late assignment into a trust and violations of REMIC tax laws has no bearing on the borrower's obligation to pay. As you can see, we attached the original note. We have the custody, chain of custody here. We have the affidavit from the creditor, which is Trust Services LLC, on behalf of the MBS 2647 MBS Securities Trust, giving us the authority to foreclose on their behalf. Whether or not the assignment was late or not, Your Honor, has nothing to do with the borrower's obligation to pay. I will present overwhelming authority that regardless of if the assignment was late or not, Your Honor, that void of that transaction can only take place from the beneficial owners of the trust. And none of them have signed anything, or the defendant did not produce any evidence that the beneficial owners of the trust told the lender to void the assignment. They have not produced that evidence. So even if their arguments were true, absence of the evidence that the beneficial owners told the trustee to void the assignment, the borrower still has not proven the burden that the late assignment into the MBS trust voids their obligation to pay. There's overwhelming authority on this. All courts have been consistent that the borrower lacks the standing to challenge any defects relating to a pooling and service agreement in which they are not a party to. And this is exactly what they are attempting to do today, Your Honor. So given by the appellate authority, even in Ivanova, post-Galaski, in New York, Irabobo, all the courts have been consistent on this. So the prosecution, the plaintiff, we argue and we plead with the court today to grant our motion for summary judgment and grant us order of possession with attorney's fees to be paid by the defendants and allow us to proceed with the selling of this property located at 3434 Tree Court Manor. That's all I have for my opening, Your Honor. Okay, so defendants, they come with their rebuttal. They're going to bring up 26 USC 860G, the REMIC laws, and Galaski. They bring up Galaski. You know, all the arguments that you see online, that's what they're bringing up in court right now. Okay. So they bring these arguments up in court. All right. Yada, 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 yada. Yada, 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 yada. Right? These are the arguments that they're bringing up. Okay. So let them, y'all just let them, just keep let them go on. Y'all just keep letting them go on. They going on. They going on. All right. My turn. It's back to me again. Okay, Your Honor. May I share my screen, Your Honor? Thank you. If it please the courts. Okay. Just want to make sure if it please the courts. All right. So, Your Honor, Exhibit A here. Exhibit A. REMIC-based foreclosure defenses rejected by courts. As you can see, so we have the table of authorities. We have Rajaman versus Deutsche Bank. We have Renegal versus Deutsche Bank, 5th Circuit 2013. Rajaman, 2nd Circuit 2014. Sigarin versus U.S. National Bank, 5th Circuit 2014. Livonia Props Holding, Appellate Court 6th Circuit 2010. In reference, Walker Bankruptcy, Eastern District of Pennsylvania 2012. In reference, Correa, 1st Circuit 2011. Butler versus Deutsche Bank in Comerica, 1st Circuit 2014. Wells Fargo versus Irabobo, New York Appellate Division 2015. Bank of New York Mellon versus Gales, New York Appellate Division 2014. Deutsche Bank versus Burke, New York State Supreme Court 2010. Jenkins versus Morgan, JP Morgan Chase Bank, California Appellate Court 2013. Ivanova versus New Century Home Mortgage Corporation 2016. Satterback versus JP Morgan Chase 2016. Bank of America National Association versus Baseman FBT LLC, Illinois Appellate Court 2012. Ferguson versus Bank of New York Mellon, 5th Circuit 2015. Your Honor, the overwhelming authority from multiple jurisdictions all across the United States have held that a borrower cannot challenge any defects or late assignments into a trust based on the pooling and service agreement in which they are not a party to. Now, the defense may argue that the assignment is void. And if we refer back to the Uhadi case that came up out of this appellate court in this jurisdiction, out of this district, Your Honor, even this court has held that in order for the assignment to be void, the one who has the right to void the assignment must declare that the assignment is void. So if the foreclosure party still attempts to foreclose on that property, then yes, that would be a void assignment based on the fact that the foreclosure was never supposed to take place in the first place. And courts have distinguished another example of a void assignment as if the contract itself should have never taken place from the beginning, meaning from the beginning, there was never, ever any contract. The defendant will not be able to pass that burden, Your Honor, because we attached their application. They signed the note, they signed the deed of trust, and they have made at least 7 payments. Now, at no point during the 7 payments that they made on this account did they make up any arguments or that the contract was void ab initio. And the fact that they made payments on the account, they are now foreclosed from making any arguments that the contract was void from the beginning because they made the payments, they agreed to the terms, and therefore they thus considered to the validity of this debt. What the defense is trying to do today, Your Honor, is they're trying to use a method that has been soundly rejected by the courts as a way to get out their obligation. And it's obvious that the defendant is trying to stage off foreclosure, thus further prejudicing our right to execute the sale based on the deed of trust pursuant to the debt, which is a tax act as Exhibit AB2 in the promissory note. That is their signature. They've signed the deed of trust, and just to rehash earlier, Your Honor, they did make payments on the account. So, Federal Appellate Authority, jury. The key thing here that I want the jury to understand, and this is going to be for your decision to make, jury, does a late assignment void the borrower's obligation to pay? Because jury, you are going to be the determining factor in this. Now, in Rajiman versus Deutsche Bank, National Trust Company, each of the jury, you have a copy. Can you please go to the first one, Rajiman versus Deutsche Bank? Everybody, just to go here and just read along. Holding. Borrowers lack standing to challenge mortgage assignments based on alleged PSA and REMIC violations. In that summary, the Second Circuit held that mortgagors are neither parties nor intended third-party beneficiaries of the pooling and service agreements. The defense may want to cite the LaSalle case with Phyllis Horst, but the defendants cited an Alabama case, and we're in California, and that has no bearing on the decisions of this court. So we ask you to strike the Phyllis Horst versus the LaSalle Bank because the jurisdictions were not even there. Alleged transfers into securitized REMIC trust after closing dates renders assignments voidable, not void. Now, I want you to decipher between voidable and void. Void meaning the transaction should have never took place in the first place, or the entity that's foreclosing are foreclosing without authority. Now, a void transaction, a voidable transaction means any transaction that is subject to ratification, meaning the trustee can go fix the defects. The trustee can go clear those errors with the third-party beneficiaries, the investors, and then everything can, get back to order. And this is common in a lot of mortgage cases when you see they cancel the hearing or cancel the foreclosure hearing or cancel the foreclosure sale. They'll cancel it for like 60, 90 days, and then they'll come back and refile the foreclosure. So avoidable assignment just means that the transaction can be ratified. It can be corrected. It doesn't mean that it's over and done with. So that's a clear distinction that I want the jury to know. The court further held that REMIC tax provisions do not create private causes of actions and that plaintiffs failed to establish Article 3 injury traceable to the alleged PSA violations. Now, the jury, one of the defendants, I want to introduce Exhibit C.3 into evidence. And Your Honor, may I play this for the jury? Thank you.
I'm gonna just try and break this down clearly to you. The trust in my client's case has been closed for 3 years. They cannot tie up any loose ends with that. Why? Because REMIC tax law prevents them from transferring any assets into the trust that aren't qualified mortgages and that are after the cutoff date and 90-day grace period for the trust. So they cannot tie up the loose ends. This is as clear as I could explain it to you.
Your Honor, it's clear as day from the record, from the recording, that defendant Alan Naji is attempting to make an argument that is based on tax law. The defendant did not present any evidence or meet the Article 3 standing requirement or produce any case law on how a tax law will have any bearing on the outcome in the foreclosure case. Overwhelming majority evidence proves that tax law and the administration thereof is been delegated to the Internal Revenue Service per Congress's power to lay and collect taxes. Now, trying to impose an executive, a legislative branch authority into a judicial branch will fly in the face of what this country was established on, and it's the separation of powers. The legislative branch does not hear case law, does not determine outcomes in court cases. This is for the judicial branch of government to do. So by that very fact alone, that argument, because of a tax violation will occur, that argument is foreclosed by the overwhelming majority. And just given the fact that this is a judicial and not a tax issue. The court further held that REMIC tax provisions do not create private causes of actions and that plaintiffs failed to establish Article 3 injury traceable to the alleged PSA violations. Okay. Let's keep going. It's the significance. It's the leading federal appellate court authority rejecting REMIC-based foreclosure defenses was the Rajaman case, Second Circuit. Now, the Renegal versus Deutsche Bank, Fifth Circuit, 2013, holding borrowers cannot challenge assignments based on PSA violations. Such defects render assignments voidable. Summary: the Fifth Circuit held that even assuming defects in execution or trust compliance, those defects were rendered the assignment voidable at the election of the trust beneficiaries, not void. Borrowers lack standing to enforce PSA provisions or REMIC compliance requirements. Significance: this is frequently cited for the void versus voidable distinction, Renegal versus Deutsche Bank. And these are all the leading controlling cases, meaning when these issues first start to become, argued, these are all the beginning courts that have already settled these. So if people were to make these arguments today, jury, the other side's lawyers are going to be pulling up these same cases to shut them down. And a lot of these cases here are appellate cases. Meaning it's already been argued, it's already went on appeal, and it's already been affirmed. So these are what we call foreclosing cases, meaning the defendants who are making these REMIC arguments, us as the plaintiff, we're telling the courts that their arguments are already foreclosed by these cases, meaning the arguments that they're making today have already been argued before and have been decided in the mortgage's lender's favor. And I want the jury to understand that we're in 2026. These cases date back to 2011, 2012. So we're almost like 14 years in on well-settled law with these. We're almost at the 20-year mark. Now, the Cigaran versus U.S. Bank, 5th Circuit 2014, holding that REMIC closing date violations do not invalidate foreclosure rights. And as we want to point out to the jury is that the defendants did not produce any evidence or any authoritative case law in which the courts have held, that just because REMICs are governed by tax law, that should be applied to a mortgage foreclosure case. They have not supported any case law that just because there's a tax violation, that the debt automatically goes away. Jury, I want to, Your Honor, if I may, I want to alert the jury that a lot of these arguments that you see today was first spearheaded by Gene Keating. Gene Keating was one of the leading proponents of using tax law to argue foreclosure cases, stating that it's a tax issue, not a debt issue. And I've seen a lot of people online today that are yelling foreclosure are tax issues, REMIC laws. Regardless if whether the foreclosing entity has elected to treat that property as foreclosed assets under the IRS regulations, which they have made those arguments before, it still does not have any bearing on whether the debt is enforceable and does the party enforcing the debt has enforcement rights, because court is not tax once again. And the contract is a binding, legal, valid contract, and we don't see any evidence on the record from the defendants why this court should not uphold the contract. The summary: the Fifth Circuit affirmed Renegal and rejected borrower arguments that alleged PSA violations nullified assignment into securitized trust. Livonia Props Holdings versus Farmington LLC holding, 6th Circuit 2010. Borrowers generally lack standing to challenge mortgage assignment validity. Summary: the 6th Circuit held that only parties to an assignment may contest defects. Borrowers may not challenge compliance with securitization documents. Now, jury, they're going to point to the Horace LaSalle case and where the judge says the borrower is a third-party beneficiary. But if you notice that no one has won that argument in Alabama since then. Actually, the judge was admonished for that ruling, and that judge never ruled like that again. Butler versus Deutsche Bank, First Circuit 2014. Borrower lacks standing to contest assignment based on PSA terms. The First Circuit held that even if the assignment violated trust documents, borrowers cannot challenge it absent proof that the assignment was void rather than voidable. And the defendants have not put anything on the record evidencing the fact that the parties who's entitled to enforce the PSA terms have rendered that assignment void. Because only the third-party beneficiaries, which are the investors in these cases, can make such a determination. The borrowers have not presented any evidence that the investors made such a determination. As a matter of fact, Your Honor, we don't think they'll be able to even meet that extremely high burden, because in PSA agreements, they're pretty much secluded and closed and not open to public inspection. So the borrower, the trust can never disclose any of that information to the borrower. It's exempt from the rules of evidence, because in order for it to be admitted in discovery, the borrower will actually have to be a party to that document, in which they're not. So it is exempt under the rules of evidence. So you won't get it anyway. Now, bankruptcy authority. Reference Walker, 2012. Holding, REMIC tax violations do not invalidate enforceability of a mortgage note. And jury, I want the jury to understand that we have went through the federal authority, and which the courts have been consistent. And now we are in the bankruptcy authority. And then after the bankruptcy authority, jury, we're going to go to the state authority. The court held that REMIC regulations create tax consequences, but do not eliminate a creditor's right to enforce a mortgage or note. In reference, Correa, borrower cannot assert PSA noncompliance to defeat foreclosure. Summary. The bankruptcy appellate panel held that debtors lack standing to enforce pooling and service agreement provisions. State authority. Excuse me. I scrolled down a little bit too fast. Wells Fargo Bank versus Irabobo, New York Appellate Division, 2015. Holding, mortgager lacks standing to challenge assignment based on PSA violation. The Appellate Division reversed a lower court decision that had accepted a REMIC-based argument. It held that alleged trust closing date violations renders transfers voidable, not void. So, Your Honor, the defendants did cite Irabobo 1, but by the reversal of the New York Appellate Court, Your Honor, those arguments are foreclosed as a matter of law. Bank of New York Mellon versus Gales. PSA violations do not confer standing on borrowers. The court reaffirmed that only trust beneficiaries may assert assignment defects. Deutsche Bank National Trust Company versus Burt. REMIC compliance issues do not defeat foreclosure standing. The court rejected borrower arguments that securitization defects invalidated the mortgage assignment. And here's the thing. When these pooling and services agreements are created with the beneficiaries of the trust, remember how everybody online says trust law, trust law, trust laws, trust law? Well, the same trust law applies. If you are not a party to the agreement, if you're not a beneficiary of the trust, no outsider can come in and claim any defects. That's just like me coming in and trying to tell y'all that y'all trust agreements are wrong. That you assigning your vehicle to your trust, the assignment is void. Basically, jury, they're basically saying is you have no dog in the fight when it comes to the PSA. You're not an investor. You're the borrower. Deutsche Bank versus Burt. Supreme Court. New York Supreme Court. REMIC compliance issues do not defeat foreclosure standing. The court rejected borrowers' arguments that securitization defects invalidated the mortgage assignment. Jenkins versus JP Morgan Chase. Borrower cannot challenge securitization pre-foreclosure. The California Court of Appeal rejected REMIC-based timing arguments as grounds to invalidate foreclosure. Ivanova versus New York Century Mortgage Corp. Holding borrowers may challenge void but not voidable assignments. And once again, in order for assignment to be void or for them to make that argument, they would have to have evidence that the beneficiaries voided the assignment. Basically, an affidavit from them. And why do you think they made it like that? Because they know the odds of a borrower ever knowing who the beneficiaries are, who the investors are slim to none. Let's go off the record for a second. These assignments, sometimes they are voided, but they'll still foreclose anyway. Why would they do that? Because they know you'll never know who the beneficiaries are. I know who they are in many cases. And they will never disclose that information to you. Do you want to know who a lot of these beneficiaries are? They're institutional investors. They're other banks. They're other banks. So they are. They're banks. They're corporations. There's securities corporations. There's hedge funds. They're your typical everyday banks as well. Yes. Do you think they're going to, knowing that you're not a party to that agreement, do you think they're going to hand that over and you can't even subpoena it? You can't even subpoena it. Because the arguments for the defense is that they violated the PSA agreements. That's the argument. So if they violated the PSA agreements and you're not a party to the agreement, you can't even request those documents because you have to lay the legal foundation for even requesting those. And since you're not a party to the agreement, it's going to be struck down. Oh, yeah. Now, Satterbank versus JP Morgan Chase. Late assignment transfer to trust is voidable, not void. The court specifically rejected REMIC closing date arguments as invalid foreclosure defenses. Bank of America versus Basement FBT LLC. This is one of the cases that I went over in my group, the Supreme Elite team, to make everybody aware that securitization arguments, holding. Borrowers lack standing to enforce PSA provisions. The Illinois Appellate Court held that alleged trust law violations renders assignments voidable only. And when an assignment is voidable, jury, the foreclosure can still take place. Ferguson versus Bank of New York Mellon Court. Alleged PSA violations do not void assignments under Texas law. So we went to California. We went to Illinois. Now we in Texas. But you notice how, since I'm quoting cases from different jurisdictions, you notice the common denominator, jury, that all of the courts are consistent in the ruling. What the defendants are trying to do is they're trying to cherry pick one-off cases, outlier cases, and apply that one outlier cases to all their students and their clients. And we know that is one of the most dangerous things you can do when you're teaching, by applying non-consistent cases to your teaching or your service repertoire. Have an update in my client's mortgage case too. We'll get through after this. After jury After y'all reach y'all verdict, I got an update in my client's mortgage case. The Fifth Circuit reaffirmed that borrowers cannot challenge assignments absent proof of voidness. Across jurisdictions, courts consistently hold: 1, borrowers are not parties or beneficiaries of pooling and servicing agreements. 2, alleged REMIC or PSA violations renders assignments voidable, not void. 3, REMIC tax provisions do not create private rights of action. 4, tax consequences do not affect enforceability of the mortgage note. 5, federal courts require concrete Article 3 injury beyond alleged securitization defects. So, giving the overwhelming majority that I have presented, I need the jury to render your verdict and put your verdict in the comments. Here's the question: does a late assignment into a REMIC trust give the borrower a right to challenge the foreclosure? And the other question is, the REMIC violations a viable foreclosure defense? Let's put it right there. I'm going to give you all 30 seconds to render your verdict. And as always, there is never any pressure.
No pressure, nah, I ain't feeling no pressure. No, I ain't stunting her, man. She wanna get on top shit, I'ma let her. With this street code, I abide to the letter. It's just me against me, I ain't feeling no pressure. There's no hoes barred with the shit, nigga, everything gon' go. Hoes come to see me, I miss a heart and hustle up with the flow. I used to stand in the crowd, but now I'm the star of the show. My 10 in the field of play, I know you niggas looking down at my toes. I'm only smoking, no pressure. I'm digging graves with the shovel. Just like Pac in my nigga bags, you should know Liddy be a rebel. They watch the corner for a stat. Watch out. My little nigga be the lookout. You broke that shit embarrassing. Like the drunk uncle at the cookout. My 10 down, you got a foot out. I fuck my bitch, never put.
You're rocking with the best. You're rocking with the best.
What is the verdict? Does the plaintiff win, or does the defendants, which are these online teachers from all platforms, do they win this argument? What is the verdict based on all the overwhelming authority that we just read? Now, to help you, just in case you're tuning in, to help you reach your verdict, let's go over the information that I provided. Let's go over there. Let's just run the case by. We're gonna run them back. Let's run all the cases. These are all the cases I cited. No, we're just gonna run them down. Rogerman versus Deutsche Bank, holding borrowers lack standing to challenge mortgage assignments based on alleged PSA and REMIC violations. We went over the summary already. Ringdow versus Deutsche Bank. Borrowers cannot challenge assignments based on PSA violations. Such defects renders assignments voidable. Sirigan versus U.S. Bank. REMIC closing date violations do not invalidate foreclosure rights. And yes, these are all controlling authoritative cases. Livonia. Borrowers generally lack standing to challenge mortgage assignment's validity. Butler versus Deutsche Bank. Borrowers lack standing to contest assignment based on PSA terms. Bankruptcy. Walker. REMIC tax violations do not invalidate enforceability of a mortgage note. Correa. Borrowers cannot assert PSA non-compliance to defeat foreclosure. State cases. Irabobo 2. Mortgagor lacks standing to challenge assignment based on PSA violations. Gales. Holding PSA violations do not confer standing on borrowers. Deutsche Bank versus Burt. REMIC compliance issues do not defeat standing foreclosure. Do not defeat foreclosure standing. Jenkins versus JP Morgan Chase. Borrower cannot challenge securitization pre-foreclosure. Ivanova. Borrowers may challenge void but not voidable assignments. And the Yehudi case, the distinction between a void and a voidable assignment, in which a voidable assignment means that the transfer can be ratified. They can fix the defects. And a void assignment means the transaction should have never took place in the first place from the application on. Now, in many of these foreclosure defenses, the borrower has signed the application, they signed the note, they signed the deed of trust, and they have at least put down payment on it and at least made a form of payment on the account. Those actions alone, it forecloses the void ab initio argument. The other instance of a void ab initio argument is that the third-party beneficiaries, which are the investors, not the borrowers, told the trustee that to void the assignment and the lender still foreclosed anyway. Well, you will have to have evidence from the investors, which you won't be able to get under discovery, and you won't be able to get under the rules of evidence because you are not a party to that same PSA agreement. So you cannot ask for any information related to the PSA agreement because you're not a party to. So that kind of puts an end to that. Satterbank versus JP Morgan. Late transfer into trust is voidable, not void. Bank of America versus Basement FBT LLC. Borrowers lack standing to enforce PSA provisions. Ferguson versus Bank of New York Court. Alleged PSA violations do not void assignments under Texas law. Across jurisdictions, courts consistently hold borrowers are not parties or beneficiaries of pooling and service agreements. Alleged REMIC or PSA violations render assignments voidable, not void. REMIC's tax provisions do not create private rights of action. Tax consequences do not affect enforceability of the mortgage note. Federal courts require concrete Article 3 injury beyond alleged securitization defects. So given all this case law, all the overwhelming majority, if you was here in the beginning, I read the summaries and all. Everything can be researched. All this can be, you can read them all yourself. The questions are on the board for everyone. Put your answers in the comments. Oh man, and we are in court, the legal myth buster. That is who I am.
You're rocking with the best.
And pretty much, I mean, that wasn't hard because let me just be honest with you. Let me be honest with you, y'all. The reason why that wasn't hard is because this is something that's been known for well over 15 years. It's not like it's something new. And the reason why I say that is because you got to think about it. This is the problem. People will see one case and they'll run with it. And the reason why I see all the cases that they cite, Galaski, Irabobo 1, all these pre-cases where they were winning off challenging. And I try to warn people. I say, y'all, they changed the rules. They changed the game. You're not winning on securitization defects anymore. They stopped that. They really put the hammer down around 2015. I started to see a shift in the elements of these arguments when in the beginning, the mortgage lenders were not challenging the rulings on appeal like 2011, 2012. But around 2013, I started to notice an uptick of the lenders challenging the lower court's ruling on appeal. And then around 2013, going into 14, I started to see the higher courts starting reversing the lower court's decision. They started reversing them. They're not a party. So when I see people online still citing that Phyllis Horse case versus LaSalle Bank that was out of Alabama in 2011, she was lucky. It's an outlier case. She was the first one on the wave. Remember, Supreme Elite Team, when I tell everybody with your arguments, you got to be the first one on the wave? Like with me. Notice how I was the first one with these arguments that I made. Do you think credit acceptance is going to settle with anybody else in this matter the next time based on these arguments? Nope. The first ones on the wave gets through the door. Phyllis Horse got through the door. But everyone after Phyllis Horse lost. That means Phyllis Horse was not a controlling case. You get what I'm saying? It's not, that's, and this is what I'm like, I don't think they get it. I don't think they get it because they'll look at cases like Galaski. They look at Phyllis Horse and they automatically assume that that's how the courts are going to rule today. And this is that lack of foresight that the Supreme Elite Team University is going to bring to you. This is what we give you. Now, the very first class of the university was a masterpiece. And it goes to show that one contract, and I talked about this yesterday on TikTok, one contract has 5 different lenses in which it's viewed from. You got the consumer side of looking at your contract. You got the regulatory side looking at your contract. You got the corporate side, your lender side looking at the contract. You have the court side of looking at the contract. And then you got the investor side of looking at your contract. Those are 5 different lenses. But many people today are only going to look at it from a consumer side. And I've told the Supreme Elite Team group this. When you keep y'all, the consumer rights were put there to contain arguments, to keep your arguments in a box. So when you only understand the consumer side, you don't understand the regulatory side. You don't understand the court side. You don't understand the corporate side. You don't understand the investor side. Your arguments can get stale. So with the consumer, everybody is only going to argue cases probably where the consumer won. So, but when those cases start to get overturned, everybody's back to square one. And this is why people, when you look online today with mortgages, everybody's arguing from that 2011, 2013 defenses where people were winning as a foreclosure defense today. That when you find someone online that's dealing with a mortgage, that's when you sign up for them for their mortgage, you best believe that is exactly what they're going to, right there. But by 2016, all those 2011 to 2013 wins were now our losses now. So what worked there, and these are the appellate courts that overturn all these 2011 to 2013 wins. So the appellate court new precedents in those districts are all rulings that you can't make as if it was 2011 through 13. So since an overwhelming majority of online mortgage teachers are only PSA violations, securitization, remix, investors paid, it goes to show by their own arguments that none of them, based on those arguments, none of them are equipped to handle anyone's foreclosure. And this is more the reason why.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby, folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines.
And this is in, you know, and this is the reality of court. Court is filled with nuances. And there's always rulings. There's always new cases. Now, let's do this. Let's do this. Now, all right. Remember the Phyllis Horse case? You see that? Remember? If y'all look online, or if you go on TikTok, if you could just go on TikTok right quick and just type in Phyllis, Phyllis, Horse versus LaSalle Bank. If you go on TikTok, you get what I'm saying? If you go, let's see if I can do it for you. See if we can do it all together. Because I want y'all to see that let me share my screen. I want y'all to see so you can see for yourself.
17:30. I'm like, hey, what's up, hello? Since your pretty ass soon as you came in the door, I just wanna chill, got a sack across the road. Now it's the money.
Good news, everybody. We just stopped the sale of a house that was getting ready to be sold tomorrow by filing a federal lawsuit and taking that paper over to those who were trying to sell it. And they stayed the entire process until December.
Ma'am, all you did was just file a notice of removal. That's when you file a notice of removal, it's going to stay the entire process. See, look, just look. Everything is, you're being sued. Foreclosure. Do something to stage it off. You rarely ever see them talking about the borrowers being the plaintiff and suing while they're current. And this is why she didn't post the case. Look here. Look here.
Good news.
This is what you call gaslighting. Because she says it's stopped in its track after filing the federal lawsuit. That's That's procedure. The state case is going to halt it. But here's the thing. The lender is the plaintiff. The plaintiff chooses the venue. Since it's not federal law that's argued in the complaint, they brought the venue in state court. The federal judge is going to remand it back to state court, but you will never know because she's not going to post that. She's not going to post when they remand it. This is December. This is October 10th, 2025. Right? Now, let's look. Okay, which one? Where were we at? Okay, let's okay, so look. That's what we just read that, right? Look. 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 Where's the case at? Where's the update on the case? Where's the update on the case? Where's the update on the case? Look. See what they do? Look. Look. Nothing about it again. Nothing about it again. Nothing about it again. Look. Let's watch it again.
Good news, everybody. We just stopped the sale of a house that was getting ready to be sold tomorrow by filing a federal lawsuit and taking that paper over to those who were trying to sell it. And they stayed the entire process until December. This is why I'm telling you, you need to fight back. It doesn't matter whether your sale is this week or next week. Fight back. Good news, everybody.
Right? And this is the one that blocked me from her live when I started calling her out on her inconsistencies. But look. Look at this. Forced discovery in court. Everything's just be the defense. Wait for them to come take you. And then you just defend it. Never know. Bring the pain to them. And this is what I mean. And this is what I mean. This is what I mean. This is exactly what I mean, y'all. Now, let's look.
Guys, this is not my account.
Okay, yeah, that happens.
So this is, I downloaded a bill that I had with Starlink. Okay, so I use Starlink for my internet connection. And I thought, okay, I'm going to do it this way. Because, see, that's why you want paper bills. You can't do it if you're just doing this stuff online. You can
secure party creditor. Let's go here.
And you want to be the secured party. You can't do this unless you do this. It's not going to work. Because with this,
if you don't have a BOE, chargeback, 2 bonds, and a Form 56, that whole stilo is in the FBI Sovereign Citizen Manual, where they say this is what they're going to do. You know what? I'm going to make you famous today, girl. I'm going to make you famous today. Watch this. Hold on. 1 second. I'm going to make you famous today. Let me see if I can find it. It's not an article. It was a I have it. It's in my files. Let me see. Let me see. It's not this one, but everything that she says in the FBI handbook, that whole thing, charge back. So we'll get back to it. Charge back, 456, 2 bonds, and to the T. And the FBI, that's on the FBI's list saying this is fraudulent. Beware. The sovereign poverty corporations, college people, professors have studied these people. New York University, Carolina, Chapel Hill, in connection with the federal government, HUD, the Urban League. They've all studied this movement, and then judges have conferences on how to deal with these people. This is why they came up at the conference of when you're dealing with a sovereign citizen who says they're there by special appearance. What did they start saying? Okay, I'm going to issue a bench warrant because the real person has not showed up. Remember that? Remember they started doing that in court. But look, ever since that case was continued to December, look.
A certificate of mailing. They'll be like, certificate of mailing, when are you going to have that for?
Just October 23. Let's go to here.
You personally? I mean,
October 30th. Nothing here. What is this?
Is what we're talking about.
All stuff they've been doing early 90s. Now,
filing bankruptcy again for 2 years. Why don't you just, I'm guessing we're talking about a mortgage or a loan or something?
That's October, right? That's November, right? Let's see when we get to December.
The truth comes out when the truth comes.
Okay, that's January. Okay, so let's get this is December.
Filing bankruptcy again for 2 years.
That's November.
Sometimes it's 10D, sometimes it's 10Q, sometimes it's 8.
10Q, 10T, 10T, it doesn't matter because you don't know how to decipher it. And you don't know how to put it evidence in court. See, they get good off buzzwords, but they don't know how to decipher it and properly admit it in court. I have plenty of cases where people attach those SEC forms of courts and the judge roll right over top of it. Didn't mean nothing. Didn't stop nothing. Because the way what they're going to do is they're just going to print it off and attach it and say, look, this is what they're doing. They're going to print the whole thing off. Them things could be over 200, 300 something pages. So you mean to tell me she's telling them to read over 200, 300 pages and read multiple ones? Like what I've done, read at least over 5,000 pages of those things and dissected them. Is that what she's telling? Do you think they would really be there? She was really telling them to do that? Now, this
is the strategy, all right? These are the documents that...
where is... First place. Now, where is... It was... Where's the update? Update. A supreme goddess. You know what happened? This is what they do. This is y'all trying to make a quick buck off ebooks. They're going to pose as students, buy your ebook, and then sell it. They're going to take they're going to pay for your ebook and then go sell it. But supreme goddess, I don't know why would you want to copy that? Because they ain't going to get you anywhere. So this is all what's going on. So you got one sovereign citizen stealing from another sovereign citizen. And supreme goddess, I know who she is. I know exactly who she is. I know what that logo is. And this is why people say, won't you just give out the information online? Give out the information. This is why I don't do it. This is why I don't teach classes like this online. This is why. Because they're all sitting in the cut waiting for me to drop big gems so they can run back to their people and sell it. That's why. And this is why they're really frustrated and mad with me, because I talk in codes and I talk in riddles and I talk around it. But you wouldn't have to worry about any of that.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby, folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines. The truth comes out.
Good news, everybody. We just stopped the sale of a house that was getting ready to be sold tomorrow by filing a federal lawsuit and taking that paper over to those who were trying to sell it. And they stayed the entire process.
Now, that was October 25th. That was October 25th. And if we scroll up, we are now in February and you don't see nothing. Nothing about it. Went on to other shit. Where's it at? Nothing. Want to know why? Because these people up here, she has to keep she got to keep it going. She got to keep the front up for them. And this is what these teachers do. You got to keep the front up for them. She thinks she knows more than what she really knows. But if that case would have proceeded to federal court, she would have definitely posted it. They wouldn't love more. They love to post their wins. We are now in February. Where's the case? Because it got remanded and she didn't want those 31,000 people to know. It's back in state court. And this is what happens. You will never know what the real outcome is when they don't win. And this is why y'all need to be on the lookout for teachers and gurus who only show you wins but never show you losses, never show you the hardships, never show you the in-betweens. They only want to make a perfect picture that everything they touch turns into gold. And that's not the reality with this stuff. You're not going to win them all. Look, we're in February. She mentioned no more about the case. Nothing. And this is typical online. It's what they all do. It's what they all do. It's what they all do. This ain't nothing new. This case right here, right?
Peace, family. We're back again with a notice of cancellation of hearing for a foreclosure of real property under the deed of trust.
All right. Remember when I told you, look, you notice how they always block out the party's name so you can't look the case up. But you know what their biggest problem is? When they got Superior Court right there, when they got the page number, Mecklenburg right there for the lot. You know what happened with this case? Someone brought it. Someone brought the house. The foreclosure, someone brought the house at a sheriff's sale. Wanna know how I know? Stay tuned for the next episode of Are You Afraid of the Dark? I don't know why I do this shit in real life. You can't hide by blocking out the party's names. I'm still going to find the case.
You're rocking with the best. You're rocking with the best.
But once again, you never see the finality. You never see the finality. Okay, look. Let me go down to just watched. Where's it at? Where's it at? Where's it at? Where's it at? Look. Look. Where's it at? Where's it at? Took it down. It's not here no more. Look. You see me clicking? This is all that's on this page. What happened? Where's it at? Where's it at? Notice how he went to the cancellation? To where? Look what they do now. I told you they just switch a topic. When they lose, they'll just switch a topic. Look. Where's the finality at? It was canceled. Ain't it supposed to restart? I know why you took it down. Does your 15,200 followers know why they take it down? This is why they hate me on TikTok. This is why they hate me. And they can't do with me what I do to them. They can't do to me what I do to them because all my shit is real. All my shit is live. All my shit's on the record. That's why they can't do it. They hate it. Look, another video taken down. Another video taken down. Right here.
Peace, family. We're back again with a notice of cancellation.
July 7, 2024. Right? Go on this channel. Let's see if it's still here. Nope. Look. You see me clicking. I'm clicking down at the bottom. Look. That's all it does. Then I scroll down to the rest of his channel. Gone. Gone. Gone.
You're rocking with the best.
Oh, man. One out of every channel on TikTok, I can find this. It's the same thing.
Peace, family.
And he sounds too young to even know what he's talking about, to be honest with you. I'm be honest with you. You sound too young to even know what all these young people swear they know what they talking about. Now, where is it? Because I saw it earlier. I saw it earlier. I saw it earlier. Where is it at? Let me do this, y'all. Let me go to videos. Yo, it's like they know I'm coming. It's like they know I'm coming. It's like they sense me coming. And this is why it's not hard to believe that I was blocked by all these gurus. This is why it's not hard to believe. Now I can't even find it. I can't even find it. This is what I'm saying. Because earlier they was all on here talking about that Phyllis Horace case. I think
the third pack is the bond pack, right? You have your private registered bonded promissory note, your private registered offset and discharge bond, non-negotiable, right? Bond.
that's what I'm. Yeah, you get what I'm saying? Look at this. Look at this. Yo, it's spooky out there, man. Bonded promissory note. Look. It's claims that your birth certificate. Look. Promissory note fraud. Look, talks about it right here. Look. Promissory note scams. Look. Look at all that. Just look. This is the SEC. They regulate this. You really want to know if it's legit? Call them. See, they don't want to call them because the reality is not going to be what they believe is true. See, look at all the energy this guy's putting into it. You think he would actually call the SEC up to see what he's doing is true because he don't want to hear the answer. Look, all this is look at this right here. What is it? Private register bond. All that is from the early 90s. Sovereign citizen. Private register bond. Private register bond. The redemption theory believes that most of their prevalent methods is to defraud banks, credit institutions, and the U.S. government. The redemption scheme. So remember when I tell you all these teachers online that comes like they're teaching, what they're really doing? They're teaching you how to commit fraud. That's all they're doing. How to commit tax fraud, how to do scams. That's all it is. Max as these are my rights. Under my rights, I'm asserting my rights under law, color law. See? And this is why the most non-like person in this space always seems to be. Why does it seem like the most non-like person in this space seems to be progressing more than all of them combined? Sovereign citizens believe that when the U.S. government removed itself from the gold standard and rendered U.S. currency as valueless credit notes, exchanging one credit document such as a dollar bill for another, they assert that the U.S. government now uses citizens as collateral, issuing social security numbers, birth certificates to register people and trade agreements with other countries. Each citizen has a monetary net worth, which they believe is kept in the U.S. Treasury Direct account, valued from $630,000 to more than $3 million. These accounts, they claim, are in third parties' names, a straw man that they can access, which they commonly refer to as freeing money from the straw man. In essence, it is extorting money from the U.S. Treasury departments. Sovereign citizens file legitimate IRS and uniform commercial code forms for illegitimate purposes. Believing in doing so, they will correctly compel the Treasury to fulfill its debts, such as credit card debts, taxes, and mortgages. And this is a representation of that. Right here.
Order, private registered bond for offset, non-negotiable bond order, right? And then you have the instructions.
The third pack. Once again, when you're trying to redeem a bond, the Treasury already, it tells you when you get your real bond where to go to redeem it. You got to send it either to the Federal Reserve Bank, you could take it to your bank, or you can mail it to the Bureau of Fiscal Service, and you got to attach a standard form to it. And you got to put the information on the bond or the coupon or the redemption coupon from the bond on there. So you notice how there's no SF form? You notice how he ain't got no Bureau of Fiscal Service form attaching it. He's just going to send it straight to the Treasury. It's going to go right to IRS in Ogden, Utah, and it's going to go right in the shredder. It just never stops. And this is like almost 40 years old right here, this scheme right here. But look at it. 803 likes, no comments, 517 saves. No, TikTok, they comment. But you ain't got, comments turned off. Of course. Of course he's going to turn the comments off when people are saying that's fraud, because that's all they were doing. Because remember, the Dunning-Kruger effect, he thinks he's an expert at this. But what never happens, because it showed like $1 million something here. You know what never happens? They never show you like they're living like a millionaire. They never show you the millionaire status. They never show you. And these people would love more to show their results. But why they always seem to get look, mysterious. Look how
is the bond pack, right? You have your private register.
Look at that. Now we go here. Where are we just at? Look at all this. Look at all this. All this is old sovereign citizen stuff. I'm telling you, bro, like they don't have a brain of their own. None of them do. It's like they all just do the same thing. None of them knows how to step outside the box and think. Now you got templates here. Like I told you. Now, where is I'm looking for that Phyllis Horse case. I don't know where I saw it earlier. Everybody's telling you how to beat court, win in court. Everybody's telling you how to win in court. Look at all this, y'all. Look. Foreclosure defense. Foreclosure defense. Foreclosure. Fraud exposed. Now, but you notice, you never see shit like this. You never see shit like that. This is what you don't see. Settlement agreement. The case is dismissed. The case is over. Notice that. Look, I left my name there. I left that there. And you can still see. You can still see the case if you zoom in. You notice that? See? This is what you don't see. See? This is what you don't see. This is what you don't see.
This is a public service announcement.
This is what you don't see.
Come on now, dog. Come on, man.
What you don't see is them being the plaintiff. This is what you don't see. It's what you don't see. It's what you don't see. So you mean to tell me that nobody from them, not the lawyer, they have a problem filing that fraudulent complaint, but nobody showed up for them?
Yeah,
wow.
Because I even asked him when we walked out. I asked him, I said, so do you work for Velocity? And he said, no, I don't. He said they didn't have anybody to come out. But anyway, he said, yeah, if they don't have somebody to come out, they put their feelers out. And
case been assigned for civil pretrial. See, this is what they don't show you. What happens after you file? What happens after they file their documents? You had one girl tell me, we filed a foreclosure October. You ain't hear nothing again. Oh, cancellation. There's no finality. See, they never show you what's the judge's order after they file the stuff on behalf of their clients like this.
Get somebody locally. I said, oh, okay, so you're local to Findlay? And he said, no, I'm actually in the Columbus area, but they didn't have anybody in this area at the time that we needed to be here. So they, I picked up the job and
see. It's what that's what they won't show you. It's what they won't show you. So that's what they won't show you. And before I forget, so we had a foreclosure case out of and hey, they came to me how they were. You know, I like for people to be the plaintiff. I really don't like you know me. Y'all know my stance on that. But hey, they came to me. They came to me. It is what it is. So they filed a foreclosure complaint. And they filed a foreclosure complaint June 23rd last year. And we responded to the actual complaint. So they filed the foreclosure complaint. And I'm pulling all these documents up for you so you can. So they filed a foreclosure complaint. We responded to the foreclosure complaint, obviously. And I don't know why it's doing that. We responded to the foreclosure complaint, and they had already assigned the mortgage to Lakeview in December, right? So they are already assigned the debt to Lakeview in December 2025, more than 6 months afterwards, right? So they had let me pull up, they had a contested phone call hearing in January 13th, right? They had a contested phone call hearing. So I hit him up. I said, yo, what's good? This is December 30th. He said, we set for January 13th, though. I said, contested phone call. And he said, yeah, it's a contested call when parties don't agree with what's submitted. So they filed their complaint. We responded, and the judge set a hearing, and they gave dates where they had to have this in by this date. They had to have this in by this date, and they got to have, we once they respond, we get the last response, right? So, mind you, they had already filed the complaint. And not only did they file the complaint, they had already substituted assigned the mortgage over to Lakeview on December 2025. Right? So my question was, if they already assigned it December 2025, why would you go to the hearing pretty much pretending that you're still going to argue the case? Now, that's not even the big issue. The issue is you filed the foreclosure complaint June 23rd. You filed it June 23rd. Right? You already knew that you already knew, you know what I'm saying? You already knew this thing. Let me see. I'm pulling it up for y'all right now. All right, let me share my screen. I'm about to just share the entire screen.
So look. So you already filed the complaint. You filed the mortgage complaint, right? And then right? Now that you have to respond to the complaint, look what you do. You filed a motion to substitute plaintiff. Right when your response was already past due. Why would you file a motion to substitute plaintiff now when you already knew you did the assignment December 2025? Now, why would you actually file the motion to substitute plaintiff now all of a sudden? Why don't you just or respond first? Now you already know we already filed our opposition to it. And that opposition, I mean, let's just be honest with you. This was another masterpiece. This is how you argue a mortgage in my response. It's really how you argue. And notice how UWM, the only thing they filed was the original complaint. They didn't even respond. And they were supposed to respond, but they didn't respond. Now it's a substitution. Now Lakeview has to stand under this scalpel. I don't know why they think that. Hey, I think it was a stupid move by them. Now, of course, for security purposes, I am not going to read my response loud because, to be honest with you, that's saved for private teaching. And this is the problem with people trying to do all this teaching online. If you really understand the game, you really understand the sauce, and you really have results to show, you will not be free willy-nilly online doing it. Nobody, they're always in private controlled settings. You don't see them live streaming their securitization classes for the whole world to see. I'm sorry, y'all. I know most people will just, I don't know, you should just give it. No, because it don't work like that. Nobody respects anything that's free. If you want it that bad, you should have no problem paying for it. Hey, just because you got scammed, that ain't got nothing to do with me. I don't care. I'm gonna be honest with you. Because if you don't, you'll be sending emails like this. Hey, I'm reaching for your services on how to use the 1099A correctly to access my account. An account that doesn't exist. I have a lot of bills, but mainly my mortgage is my focus. Does your method result in I don't have to pay anymore? Look at the mindset. This is the mindset of people. This is what they think this space is about. This is the shit that they think. This is the shit that they think. This is the shit that they think is like what this space is about. Oh, I'm in financial turmoil. Oh, I can go over here. I don't got to pay no more. And I get money out of an account that I don't even understand. All right, sign me up. And does it work? I don't want to experiment on my mortgage. The last teacher ran off with my AK when I showed him the rejection letter from the bank. Talking about skip the boss here. So I had to pay all the fees because he told me due to HJR 192 that I didn't have to pay. I told the bank I could pay it with my straw man account, and he sent me court cases where people tried the same thing. It didn't work. Whoa! That sounds strikingly similar. That sounds strikingly similar.
You're rocking with the best.
That sounds similar.
You're rocking with the best.
What does the new culture do to show people don't work? Show court cases. What did I say? That the banks, finance companies ain't gonna take no run right over top of you unless you can prove that you can win.
You're rocking with the best.
What did the bank do? What did the bank do? Show court cases where people tried it and didn't work. What does the new culture do? Show court cases where people try it and don't work. See, me and the professionals are on the same page. Let me acknowledge some people in the chat. Motion to substitute plaintiff. Who's even thinking that deep? Except for top litigators in the world. How could people sell fraudulent documents and get away with it? I have no idea. Oh, well, I will tell you this. See, these teachers, they do a very good job, ladies and gentlemen. They do a good job at actually hiding. They do a good job at actually hiding the, y'all know, they do a good job of actually hiding. That's what you get. They do a good job at hiding the losses. So when you lose, they block you and run away. Still selling templates, still in the basement. Oh, they are most definitely in the basement. I seen that one dude said the Constitution was made for white people. Oh, y'all seen that? Oh, by the way, he responded to my that dude responded to my, made a video about my comment, and I proceeded to tag him, showing him all my receipts, and then he ended up blocking me. See, he just got loud and yelled. It's true. I just backed it up with receipts, and just like the rest of them, every time I talk with my receipts, they run. See, as long as we just argue back and forth, I think everybody's good with that. But when I'm ready to shut the argument down, I just drop receipts on them. They run away and never come back. Yeah. And I can look up the case even when you redacted it. If you don't, do not show no case around me if you don't want that shit to be exposed. Don't. According to your conversation with your friend, the attorney, what we go over in group is right in line with the legal standards and the professionalism on how it has to look and what you need to know when you attack these people.
The words that he used was, "You're going about it standard operating procedures."
Yep. Standard operating procedures. Now, what does it say? I just need the right way. Can you briefly explain how would you go about it? I don't need detail. I just wonder if you're going to use any tax funds. It will be a general letter. Lastly, is there really a straw man account with billions in it? Yo, y'all, can I ask you a question? Can I ask y'all a question? Who is actually falling for this stuff? Who's actually falling for this stuff? Guess who's falling for this stuff? People who are in financial turmoil. People who are in vulnerable financial positions fall for this stuff. Y'all, give me 1 second.
All right. So this, if you look here, this is the overall mindset of these spaces. Many people in these spaces, actually, they still want to hold on to the to the to the dream. They want to hold on to the dream, and it really goes to show that if you don't teach them what they believe, they won't believe you. No, I ain't gonna say they won't believe you. They don't want to listen. They don't want to. They don't want to listen if it's not what they believe. And this is why, this is why it is the way it is. Now, remember, if y'all don't know, they've been running around with this Phyllis horse. Hold on, y'all. I'm trying to remove that from my screen. My back screen done locked up. My back screen done froze. But nevertheless, it's still a good thing. But I want to show y'all something, because this is a good example of why the Phyllis horse. And I was trying to find it on TikTok. If one of y'all could go on TikTok and try to find the Phyllis horse, for me, because I was on it earlier and I could find it. I don't know why I'm having a hard time finding it on TikTok. It's like I just got. It's like they just stopped. So let me show you. Actually, I have to find it because it actually makes it. It makes it actually better. Phyllis horse mortgage defense case. I got to try to find it for y'all, because let me see. It might be right here. And this when they say all mortgages are fraudulent, former owners come together. None of that means any. They think this is the problem. They think that just because you know that that's all there is to it. Now, let me see.
The question that comes to mind is, if no loan was provided, you offer me $2,000, even though it has 120,000.
And they keep saying no loan was provided. A loan was provided. A loan was provided, y'all. Now, I'm going to look for this Phyllis Horace case. An attorney said I was true. Like even the stuff they say from an attorney saying I was right. An attorney telling you that you're right. There, it has not, like, an attorney can tell me I'm right all day, right? An attorney can tell me I'm right all day. Unless I go into court, right? And bam, get it done on my own, it means nothing. So, where's the Phyllis Horse? Let's look for this Phyllis Horse case, because I saw it earlier. If y'all found a link, please let me know, because the Phyllis Horse, it's actually going to make sense. Now, what did I do earlier?
I think I used this. I think it was somewhere in here.
Welcome back, everybody. Today we're going to get into some prevalent information. And in this, now it's time to harm in this proceeding. Into that, call, I guarantee you, when it comes to these things, information, so you can tackle what you need to tackle when it comes to your personal situation. If you have harmed by this, that's one of the stuff you're going to have to do. If you want to dismiss the case, you need to know how to do.
Look. Warranty deed, Form 56, Form 56F, 1099A, 1099B, 1099 OID, common law copyright, assumed name certificate of affidavit. Look, it's all sovereign citizen stuff, y'all. It's still the same old sovereign. It's the same. Like, they don't, like, do they actually consult with each other? Because I'm trying to figure out, where did these fellas, this
is a federal hearing, so therefore they've already got
TikTok, what's up?
Where is
TikTok, I'm back.
If you have your original closing mortgage documents available, you will be able to flip through them and see what the mortgage company has done to defraud you. The two main documents that I will be referencing will be the note and the deed of trust, aka mortgage. The note is commonly referred to as a promissory note. However, it is not a traditional promissory note. At the end of this mortgage fraud settlement process, which takes 2 to 4 months to complete, you will have battled the bank's trustees to obtain your property.
That's a lie. You never know when it ends. It ends. This is what I'm saying.
In the event you've already lost your home due to a foreclosure, you may have grounds to sue the bank for 1. Breach of fiduciary duty, 2. Fraud, 3. Estate embezzlement. All promissory notes and mortgages are null and void for fraud and breach of trust on the part of the mortgagee, which is the lender in a mortgage, typically a bank, who never fulfilled their portion of the agreement and never...
You see what I'm saying? Fraud. You see what I'm saying? Do y'all know what the word fraud is used for? They use fraud to fill in the blanks of a system that they don't understand. So when they don't really understand, that's where fraud comes in at. Fraud replaces lack of understanding. They don't even understand the court rules. So just by them saying, they look at fraud like, look at this. Does anybody know how to stop a foreclosure? Yes, I do. But when you this whole thing here is just cap.
Audience, Richard. You must be a debtor under the jurisdiction of a court in the county.
the third of the most banks are illegally foreclosing on people, and here's why.
Did you guys know that the bank actually gets paid at the time of the closing, and now they want to foreclose on your house after they've already gotten paid? Yeah, they securitize your mortgage, they bundle it, they pool it with a whole bunch of other mortgages, They're making the money. You gave them the credit based on your...
See, this is why they don't know accounting. I told this is the same old understanding they all have. This is why I'm head above shoulders of all these teachers. They don't know 5% of what I know, because they wouldn't be saying the things that they're saying. Number one, the banks don't get paid. It's not the bank that's getting paid. That's not how it works. Remember, looking at this is when you only look at the contract from a consumer level and thinking you know securitization. They don't understand securitization. That contract got 5 different tentacles to it. It's not about who got paid. It doesn't even matter. So this is what they let people to believe. The foreclosure, they already got paid. Now they're trying to sue you for, again. The banks don't get paid. This is why this same person
would never post the end results of her filing that case in federal court. Remember in October? You notice you ain't hearing not a peep about it again? Oh, the federal courts is rocket docket. So October, November, by at least January should have had something. You know, want to know what happened? What she don't want to let people know? It got remanded. That's what happened. Anytime they post something and then they just stop, you don't hear no more about it again, that means it didn't go good. Because if it would have went good, they would have still been posting about it. They still would have showed it. But since it didn't go good, they stopped. And that's all that you need to know about this clown.
Good news, everybody. We just stopped the sale of a house that was getting ready to be sold tomorrow by filing a federal lawsuit and taking that paper over to those who were trying to sell it.
And this is the same one, the same video. You ain't post nothing since then. So we already know it got remanded.
You need...
Welcome back to part 3 of Mortgage Fraud Exposed. The proof of what I've been saying is in the language of your deed of trust. It's in black and white.
And this is another thing. They look, oh my gosh. These people, boy, they just won't stop.
TikTok. I'm going to keep it short and sweet, under a minute. As you can see here, another foreclosure stopped.
But here's the thing. The foreclosure was stopped. Where's the documents to show it? Where's the cancellation letter at? Where's the finality? This is all they do, y'all. Show text messages and DMs. I stop foreclosures. I don't. It's the problem. You stop foreclosures. I help people win as the plaintiff and get free and clear title to shit. It's a difference. You help people stay in a defensive mindset. I help people go out and take charge and be the aggressor. It's always these text message wins.
I'm here on behalf of the appellant.
Did you get a 1099-C? Then foreclosure happened anyways? If your mortgage company sent you a 1099-C and then...
Bro, you don't even look like you... Just look at you. Come on, man. Get out of here.
There's one last thing that I forgot to tell you guys about foreclosures.
Of course.
Did you know that you can stop foreclosure?
Of course. They are. It's always something less. Oh. Here's the last final. Pay me $500. Oh. Here's the one more final piece. Pay me $350. Oh. This will be the last one forever. Hey, give me $200. Oh. You see, you didn't get it because you didn't tell me about this. Get the fuck out of here, man.
Let's talk about loan modification denial.
So I deposited a check for a client 2 weeks or so ago for $200,000. Not a personal injury case. In fact, this client just lost their home in a foreclosure, but they made money off of it. How's that possible? My name is Attorney Esther Albert. I am a surplus or excess funds attorney here in the state of Georgia. Let me tell you about how I can get clients money from the foreclosure of their home. So everyone knows, typically, when you buy a home, you sign this huge contract, right? It's usually called a security deed or some other security instrument.
Oh my gosh, this has to stop. It has to stop. Oh my gosh, it is not that complex. And it's just, I know what she's talking. You know what? I'm just going to keep that. It's everybody thinks it's depending on what state you in. Just stop. Just stop. That's just.
All right, y'all. So let me do a quick story about.
Care about your ticket. So if you feel breaking the fucking law, asshole. You're talking about a fucking ticket.
Behind on your mortgage, or maybe you're facing foreclosure.
Are you facing foreclosure and don't know where to turn? You're not alone, but there's hope. The National Foreclosure.
If you have your original closing mortgage documents available, you will be able to flip through them and see what the mortgage company has done to defraud you. The two main documents that I will be referencing will be the note and the deed of trust.
how would you know if they're really defrauding you if you don't know how they operate behind the scenes? How would you know they're really defrauding you if you don't know it from a corporate, regulatory, and investor side? And let's say you do know. How are you going to bring those arguments under the court based on how the courts look at these contracts? See, these are the things that they don't tell you, but you have to know. They're leaving 95% out. It's all buzzwords, all emotional, get you all emotionally charged so you can just throw money at the situation. That's it. But you never see any of them showing, I got this person out this debt. You never, ever see them doing it. You never see them doing it. It's like you never see it. You never see them do it. It's all the same. Same. Show you how to do this. I'm gonna show you how to do that. Oh, do it this way. Do it this way. Hey, I'm gonna show you how to do it. Hey, you need to learn how to do this. You need to learn, and you're gonna do it this way and do it that way and go do it this way. Oh, they said it wasn't legit. Oh, nah, that's because they didn't do it. You hold on, let me call you back. The number you have reached is no longer in service. Of course. Of course. It's always like that.
Okay, so it looks like on our side we do not hold a copy of the deed or the title.
The county will actually have the deed to the home.
Correct, with the county. What was that?
What is anything show? Is it showing up satisfied on her mortgage account?
I haven't even pulled that side. Give me just a moment. That's just dinner one.
Oh, okay. Oh, yes, ma'am.
Just a moment here. Okay, it looks like the balance is 0.
Okay. All right.
Balance is 0.
Okay.
Okay, it looks like the balance is 0. 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 Okay, it looks like the balance is 0.
Like, just stop, y'all. Just stop. Stop with all these defenses. Never no follow-up with them on the phone. Never no finality. It's never them calling to get full confirmation. It's never that. It's none of that. None of them are ever on the phone. Auto mortgages. Call me auto. I know how to help with the auto too. To them. I know how to help with autos. Yeah, get this template. Get out of your auto loan now. You don't have to worry about auto. I got you. Get out of an auto. I know how to do the auto. Just follow me. Just listen to me. Do you know that they never loaned you anything? Uh-oh, there goes that emotional trigger. Do you know that you don't have to pay anything back? Uh-oh, there goes another emotional trigger. Do you know that they defrauded you? What? I've been paying all this interest and they defrauded me? Emotional trigger. Oh, they did? You'll get me out of it? Take my money. That's all what they know what words to say to trigger emotion. I know how to get you out of autos. I know how to do it. It's never. I was able to do it. It's always, I know how to do it for you. It's never, I can save you because I know how to save myself. Now I don't have to be desperate and sell shit to you every 5 seconds because I no longer have a car note. So I can be relaxed and chill. I need to hurry up and sell this auto defense to you because I need to go pay my car note. all it is with them. So check my credit acceptance app, and after the past several days of talking to them, basically trying to get them to settle with me, and they said they were open to, just releasing me from the lien and taking the vehicle. But no, I have some equity built in on the other side of the contract, which you will find out in the webinar if you join. So I called 2 days ago. They was like, yo, have your lawyer reach out to us and we can get the settlement process started. But CAC is not going to be negotiating directly with you. So I said, oh, you won't you? Well, since I'm pro se, the attorney, you're actually, you're going to have to talk to me. The federal courts is not going to make me get a lawyer when I have the right to come pro se. So I checked today, and this. Now, normally, you log into the app, you can see everything. It's right on demand. But now, and I tried about 3 or 4 times, that nothing. And the lawsuit is actually not even filed yet because I tried to do it Friday online, but United States District Court for the they will never be able to even come remotely close to the scalpels that's in those documents. Never. None of them combined. Fourth Circuit, they don't allow you to do it online, so you either got to mail it or go in the office by itself, and file the paperwork, the lawsuit. So I am still filing the lawsuit Monday, and if we reach a stipulation, then we'll do a proposed stipulation to dismiss the suit if my reasonable demands are met. But it just goes to show, because I sent them a very detailed email and attachments of every single thing that I was going to raise in the lawsuit. I didn't hide nothing. And I sent them what I was going to request in the discovery. Then and sent them motion to strike arbitration. 29 pages of the lawsuit. Also, I sent them a copy of what I will be reporting to the IRS on. Now, we have not officially reached a settlement yet. At least I'm unaware of it. But I know how credit acceptance operates. They are not about to make this an NA, or you can't do this now, or none of that, when there is something wrong with their ability to collect, or there's something going on as a legal matter. Any other time, you can log into the app, you can see when your payments made, the last payments made. I told them as of July 1st, all the payments will be making to the court. So I have July's and August payments that I will be depositing into the court. And I sent them an email and the screenshots of the money orders I took out for the payments. And I said, hey, if you want these, you're going to have to meet me in court to get them. So I have the money to pay. It ain't about not being able to pay, and they want to use this to get out of it. Damn, I made damn near $40,000 last month. It's not a big deal. Could pay the whole thing off right now if I wanted to. But no, it's about asserting my rights, still paying on the contract for over a year while I was gathering the information so I can present my claims in peace instead of trying to do it because my back against the wall and they're trying to take my stuff. No, we make sure we have sufficient funds to cover the obligations until it's time to take it to the legal proceedings. And then all the payments that I will make to them
we're going to get money orders and we're going to deposit those payments within the court. See, that's the right way of doing things. See, I know that is not a popular way with most people, because most people only do this when they can no longer afford the bill or don't want to honor their obligations, and then wonder why their outcomes are the way they are, because their spirits and their energies and their inner intent are devilish. They're not coming in good faith. They're not coming with righteous intentions. They don't have real legal valid claims. Only, hey, I can't afford to pay anymore, don't want to pay anymore, and I want to use a loophole. No, we're going to pay until it's time to bring the legal suit, and then we're going to take money orders out and pay the courts. So what I'm saying is, everything that I talk about, everything, the paper trail, the lawsuit, and the lawsuit is not even officially filed yet, but they received the email and they know damn well what is going to happen, what's going to transpire. So the escalations department, you can say you're not going to negotiate with me, but I guarantee you when it was forwarded to the lawyers, I guarantee you their sentiment and tones are very different. This never happens like this before. It never happens like this. It never does. Absolutely nothing is shown. Nothing. If it was past due and stuff and they're still in force, it will show up like red, past due, pay this now. This is a NA. Can't do nothing. Try to call, can't do nothing. Just nothing. And you got to understand the type of claims that I raise, very detrimental to their operations. So like I said, my webinar, you're going to learn these things from an accounting standpoint, IRS standpoint, court case standpoint, security standpoint, so you can start to get some of the righteous results based on your righteous intent. And I know people work hard to pay their bills to find out the underhanded stuff that's going on. So of course, hell yeah. Hold on, we ain't about to be no dummies. I get it. But let it develop the righteous way instead of trying to use it as a loophole to get out of something, because your inner intent has a lot to do with the type of people you encounter, your assigned lot in this, and the outcomes that you actually get versus what you want. A greedy, devious, prideful, wrong intentions, these spirits that a lot of people come into these spaces with under the guise of being free and knowing my rights, is a reason why a lot of them don't ever get the results they're looking for, because their inner spirits and their inner intent is always off. I knew every time I was making a payment, like, this is some BS, I know what they're doing, but I still made the payments until it was time to pull the strings.
Reminiscing the good old days. You're rocking with the best. To forget all the bad ones. I remember when you're rocking with the best. But is it worth it? You're rocking with the best. That is to me. I know for sure it's not a fancy degree. I'd like to do what I love.
$16 months of dedication, hard work, and research in preparing my lawsuit. And I can come to you in preparing my lawsuit, and I can come to you on good authority today to tell you that we have reached a settlement in the credit acceptance matter.
You're
They said
rocking
take
with
the
the best.
deal. They say you can't win. Time is read the fine print, smile.
Ended 2025. All talking, posting everything they do every 5 seconds. Every document they put together, they posting it. They're correct. I would stay far away from them, because no matter how you look at it, it's all the variation of the same sovereign citizen. So it doesn't matter how it's it is. The court proceedings are going to play out how they always go, and they're not going to speed it up or give you favoritism just because you need to keep your house or your vehicle in the moment. The court system is the court system, and feelings and emotions have no business inside of a. That's pretty much the preliminary settlement terms. I got you. This one email is more than what any of them ever got.
You're rocking with the best.
Listen, I'm gonna tell you this. I'm the only one that has ever in these spaces in the last 30 years that could produce something like this. Credit acceptance will close your account and forgive the outstanding debt. Credit acceptance will agree to request the deletion of its trade line from your credit report. The parties will dismiss the lawsuit. Credit acceptance will close your account and forgive the outstanding debt. Credit acceptance will agree to request the deletion of its trade line from your credit report. The parties will dismiss the lawsuit with prejudice. The parties will agree to mutual release of claims. The party will enter into a confidential settlement agreement. None of your gurus will ever get that.
You're rocking with the best.
None of them. None of them. I am your teacher's teacher. I have discussed settlement with my clients and shared your proposal from yesterday. Come get your auto defenses from me. Just listen. Just trust me. I'll do it. I can't get myself out of my own, but for somehow I'm an expert for all of yours. We know. I know.
Tell them that's my quiet leader. Time and started teaching.
What if I told you you were right?
Yes.
And he says, from our initial talk, he said, your things that you got and you're preparing for whoever you're doing it for. He said, it's point on. He said, you're absolutely right.
Wow. Wow. And the U.S. District Courts as well.
Yeah, as U.S. District Courts as well. He said, that's where you tear them the fuck apart.
Yep.
And he says, when I get done with them, he said, they don't even have a leg to stand on. He says, they go in the back rooms with me and settle out.
SEC attorney. What did you say again?
Fuck apart.
Yep.
And he says, when I get done with them, he said, they don't even have a leg to stand on. He says, they go in the back rooms with me and settle out.
What?
Yep.
And he says, when I get done with them, he said, they don't even have a leg to stand on. He says, they go in the back rooms with me and settle out.
Hold on. You're ex-SEC. You the big dog for real. What did I do with you? When you get done, what happens again? Hold on, I have my headphones in.
Yep.
And he says, when I get done with them, he said, they don't even have a leg to stand on. He says, they go in the back rooms with me and settle out.
You're rocking with the best.
They say you can't win. Time is read the fine print, smile. Say, watch this dance, watch this.
Oh my God, it's that. I'm not even at my best yet. I can't slow down, it's a death threat. She said, oh, it's really cause of me. I'm like, yes. Diamonds in the cut, I ain't need a medic. Like a brown skin, big booty, yeah. And her name and legacy said, I'm not your girl. Don't call me a level, sorry, you right. That's my bad. That shit get tricky when you running out of bands and the crew really like me. I'm the man. I'm like, girl, I'm in the zone. I'm like, girl, leave me alone. We done made it all the way from basement home. So what the fuck do you want? Yeah, like, girl, what you want? I told her do not call my phone. I told her do not call my phone. And now they all on my drip. Yeah.
It's really all on my drip. Hey, we really all in the mix. It's really all in the mix. Yeah. Oh my god, this that. I'm not even at my best, yeah. I can slow down, is it that threat? She said, oh, it's really cause of me. Yeah. I'm like, yes. Said I'm not. Run it up, run it in bang. Whipping up heat, got sauce in my hand. She rolling the dice, got luck in that van. Smoking that leaf, going global stand. On my wrist like a stage, I can't glance. You look like you wanna let go straight. What's up? I thought so, okay. I'm back in this symphony, stuck on the band. What's up? I thought so, okay. Yeah.
It is spooky out there in them streets. It is spooky. It is spooky, y'all. But we are not going to trip because they all have their own way of doing things. And I have my way. And if you're not doing it my way, you won't win.
Empire Talk, Boardroom Aura, New Culture, we set order. Thomas in the lobby, folder thicker than a skyline. Credit acceptance on a resume, war stories in the fine line. Supreme elate, circle around the table, every seat a throne. Consumer finance in his bloodstream, built it from a student loan. He can read a balance sheet like a judge retone. See the trap in every clause before the ink is dried on. They sell dreams on installments, he just audit the spell. Break a predatory scheme down to decimal hell. Securitization flow, turn a contract to a bond chain. He can trace the money trail backwards in a rainstorm. Same lane, receipts in a briefcase, dates, times, bank names. You bring vibes to the courtroom, he bring numbers in case names. Supreme elite, we don't speak, we fire. He got receipts line by line, no smile. In the dark where they hide those fees, we light up the fee sheet. Breathe with these. Supreme elite, we don't speak, we fire. He got receipts line by line, no smile. In the dark where they hide those fees, we light up the fee sheet. Breathe with these. He seen lenders flip scripts, turn a whip to a shackle. Interest climbing every month to your paycheck battle. But he peeled back price and APR under the mask. See the spread versus the funding, who's skimming off the past. He no charge off, roll rates, lost curves in his sleep. How they package up defaults and sell pain on Wall Street. He cross-check statements with the filings in the forecast. Find a misstep and turn one comma to a court clash. Consumer on the stand, heart racing in the cheap suit. He translate legalese, the plain talk, clean truth. Litigation in his left hand, excel in his right. Tell the judge what the bank did, cell by cell, line by line. Supreme elite, we don't speak, we fire. He got receipts line by line, no smile. In the dark where they hide those fees, we light up the fee sheet, breathe with ease. Supreme elite, we don't speak, we fire. He got receipts line by line, no smile. In the dark where they hide those fees, we light up the fee sheet, breathe with ease. They move in the margins, he read in between. They hide it in footnotes, he pull it on screen. From the boroughs to the boardroom, same concrete. Thomas built a whole empire off one word, receive. Pay vision, JD rhythm in his cadence. Double check the debits, then dismantle all the plaintiffs. Underrated models, he can see where they cheat. Assumptions too rosy on a loss rate sheet. Dockets on the desk, he align them like a chessboard. Case law, cash flows, every step, next chord. Supreme elite follow, blueprints not gossip, they talk bag. He talk tax, keep profit, new culture empire. This is financial defense, teaching credit as a weapon, not a lifelong sentence. From credit acceptance battles to the hallways of appeal, Thomas turned every closed door to a signed, sealed deal. Supreme elite, we don't speak, we fire. He got receipts line by line, no smile. In the dark where they hide those fees, we light up the fee sheet, breathe with ease.
got sauce in my hand. She rolling the dice, got luck in that van. Smoking that leaf, going global stand. On my wrist like a stage, they can't glance. You look like you wanna let go straight. What's up? I thought so, okay. I'm back in this symphony, stuck on the band. What's up? I thought so, okay, yeah. Run it up, running it bang. Whipping up heat, got sauce in my hand. She rolling the dice, got luck in that van. Smoking that leaf, going global band. It's bang. Fresh white tee, chrome on the rim. Big body slide, whole block look slim. Wrist on chill, but the boy too hot. Turn my last L to a key to the spot. Plug on the phone, said say let's slide. Came from the back, now we front row live. Couch full of cash, can't sit, can't fold. Used to pray for a play, now it's overload. Run it up, running bang bang. Whipping up heat, got sauce in my hand. She rolling the dice, got luck in that van. Smoking that leaf, going global. Ooh, expand. Blue. Shorty too thick, attitude too. Say she want a boss, not a boy in the crew. Stamp my name on the side of her glass. Say she feel safe when I'm hitting the gas. Mama in the crib, fridge stay packed. All them long nights, put food in the stack. Talk about stay down, I really did that. From the floor to the floor type check. Had nothing but hope in the half tank. Now it's 10 toes down, all gas. No thanks, till they cross that line, that's a bad move. We don't double back, we just improve. Running mid-range. Whipping up heat, got sauce in my hands. She rolling the dice, got luck in that van. Smoking that leaf, going global. Expand.